A good morning, friends. Today we are going to discuss assessment, section 59 to 64. Self assessment. The word itself, self assessment, says that every registered person shall self assess the taxes payable under this act and furnish a return for each tax period as specified under the section 39. Section 60. Provisional assessment. Subsection 1. Subject to the provisional provisions of the subsection 2, where the taxable person is unable to determine the value of the goods or services or both, or determine the rate of tax applicable thereto, he may request the proper officer in writing giving the reason for the payment of tax on a provisional basis, and proper officer shall pass an order within a period not later than 90 days from the date of the receipt of such request, allowing the payment of tax on the provisional basis at such rate or on such value as may be specified. Subsection 2. The payment of tax on the provisional basis may be allowed if the taxable person executes a bond in such form as may be prescribed and with such surety or security as the proper officer may deem fit, binding the taxable person for the payment of difference between the amount of tax as may be finally assessed and the amount of tax provisionally assessed. Subsection 3. The proper officer shall, within a period not exceeding 6 months from the date of communication of order issued under the subsection 1, pass the final assessment order after taking into account such information as may be required for finalizing the assessment, provided that the proper officer provided that the period specified in this subsection may, on the sufficient cause, been shown and for the reasons to be recorded in writing, be extended by the Joint Commissioner or Additional Commissioner for the further period not exceeding 6 months, and by the Commissioner for the such further period not exceeding 4 years. Subsection 4. The registered person shall be liable to pay interest on any tax payable on the supply of goods or services or both under the provisional assessment and but not later not paid on the due date specified under the subsection 7 of the section 39 or the rule made thereunder at the rate specified under the subsection 1 of the section 50 from the first day after the due date of the payment of tax in respect of the such said supply of goods or services or both till the date of actual payment, whether such amount is paid before or after the issuance of order for the final assessment. Subsection 5. Where the registered person is entitled to a refund consequent to order of the final assessment under the subsection 3, subject to the provisions of the subsection 8 of the section 54. Interest shall be paid on such refund as provided in the section 56. 61. Section 61. Scrutiny of returns. Subsection 1. The proper officer may scrutinize the returns and related particulars furnished by the registered person to verify the correctness of the return and inform him of the discrepancies noticed, if any, in such manner as may be prescribed, and seek its explanation thereto. Subsection 2. In case the explanation is found acceptable, the registered person shall be informed accordingly and no further action shall be taken in this regard. Subsection 3. In case no satisfactory explanation is furnished within a period of 30 days of the being informed by the proper officer or such further person as may be permitted by him, or where the registered person after accepting the discrepancies, fails to take the corrective measures in his return for the month in which the discrepancies is accepted, the proper officer may initiate appropriate action, including those under the Section 65 or the Section 66 or the Section 67, or proceed to determine the tax and other dues under the Section 73 or 74. Assessment of non-filers of returns. Section 62, subsection 1. Notwithstanding anything to the contrary contained in the section 73 or 74, where a registered person fails to furnish the returns under the section 39 or the section 40, even after the service of the notice under the section 46, the proper officer may proceed to assess the tax liability of the said person to the best of his judgment, taking into account all the relevant provisions, materials which is available or which he has gathered, and issue an assessment order within a period of 5 years from the date specified under the section 44 for furnishing of annual return for the financial year to which the tax not paid relates. Subsection 2, where the registered person furnishes a valid return within 60 days of the service of assessment order under subsection 1, the said assessment order shall be deemed to have been withdrawn, but the liability for the payment of interest under the subsection 1 of the section 50, or for the payment of the late fee under the section 47 shall continue, provided that where the registered person fails to furnish a valid return within 60 days of the service of assessment order under the subsection 1, he may furnish the same within a further period of 60 days on the payment of additional late fee of 100 rupees for each year day of delay beyond 60 days of the service of the said assessment order, and in case he furnishes valid return within such extended period, the said assessment order shall be deemed to have been withdrawn, but the liability to pay interest under subsection 2 1 of the section 50, or to pay late fee under the section 47 shall continue shall continue. Then section 63, assessment of unregistered person, notwithstanding anything to the contrary contained in the section 73 or the 74, where a taxable person fails to obtain the registration even though liable to do so, or whose registration has been cancelled under the subsection 2 of the section 29, but who was liable to pay tax, the proper officer may proceed to assess the tax liability of the such taxable person to the best of his judgment for the relevant tax period, and issue an assessment order within a period of 5 years from the date specified under section 44 for furnishing of annual return for the financial year to which the tax not paid relates, provided that no such assessment order shall be passed without giving the person an opportunity of being heard. Section 64, Summary Assessment in certain special cases. Subsection 1, the proper officer may, on any evidence showing a tax liability of the person coming to his notice with the previous permission of additional commissioner or the joint commissioner, proceed to assess the tax liability of the such person to protect the interest of revenue and issue an assessment order if he has sufficient grounds to believe that any delay in doing so may adversely affect the interest of revenue, provided that when the taxable person to whom the liability pretends is not ascertainable, and such liability pretends to the supply of goods, The person in charge of such goods may be deemed to be a taxable person, liable to be assessed and liable to pay tax and any amount due under this section. Subsection 2, on an application made by the taxable person within 30 days from the date of receipt of the order passed under the subsection 1 or on his own motion, if the additional commissioner or the joint commissioner consider that such order is anomalous, he may withdraw such order and follow the procedure laid down in the section 73 or the section 74. This were about assessment. Let us discuss about audit. Audit section 65 to 66. The section 65, audit by the tax authorities. Subsection 1, the commissioner or any officer authorized by him by way of a general or specific audit may undertake audit of any registered person for such period at such frequency and in such manner as may be prescribed. Subsection 2, the officer referred to in the subsection 1 may conduct the audit at the place of business of the registered person or in the office. Subsection 2 3, the registered person shall be informed by way of notice not less than 15 working days period to conduct of audit in such manner as may be prescribed. Subsection 4, the audit under the subsection 1 shall be completed within a period of 3 months from the date of commencement of audit, provided that where the commissioner is satisfied that the audit in respect of the such registered person cannot be completed within 3 months, he may, for the reasons to be recorded in writing, extend the period for a further period not exceeding 6 months. Explanation for the purpose of this subsection. The expression commencement of audit shall mean the date on which the records and other documents called for by the tax authorities are made available by the registered person or the actual institution of audit at the place of business, whichever is later. Subsection 5. During the course of audit, the authorized officer may require the registered person to afford him the necessary facility to verify the books of accounts or other documents as may require to furnish such information as may require and render assistance for timely completion of the audit. Subsection 6. The on conclusion of audit, the proper officer shall within 30 days inform the registered person whose records are audited about the findings, his rights and obligations, and the reasons for such findings. Subsection 7. Where the audit conducted under the subsection 1 results in detention of tax not paid or short paid or anomalously refunded or input tax credit wrongly availed or utilized, the proper officer may initiate action under the subsection 73 or the 74. Special audit. The special audit section 66. Subsection 1. If at any stage of scrutiny, inquiry, investigation, or any other proceedings before him, any officer not below the rank of Assistant Commissioner, having regard to the nature and the complexity of the case and the interest of revenue, is of opinion that the value has not been correctly declared or the credit availed is not within the normal limits, he may, with the prior approval of the Commissioner, direct such registered person by the communication in writing to get his records, including books of accounts, examined and audited by the chartered accountant or the cost accountant as may be nominated by the Commissioner. The subsection 2, the chartered accountant or the cost accountant so nominated shall within the period of 90 days submit a report of such audit duly signed and certified by him to said assistant commissioner, mentioning therein such other particulars as may be prescribed, provided that the assistant commissioner may, on the application made to him in this behalf by the registered person or the chartered accountant or the cost accountant, or for any material and sufficient reason, extend the period by the further period of 90 days. Subsection 4 3. The provisions of the subsection 1 shall have the effect notwithstanding that the accounts of the registered person have been audited under this any other provisions of this act or any other law for the time being in force. Subsection 4. The registered person shall be given an opportunity of being heard in respect of any material gathered on the basis of the special audit under the subsection 1, which is proposed to be used in any proceedings under against him under this act or the rules made thereunder. Subsection 5. The expenses of the examination and audit of records under the subsection 1, including the remuneration of the such chartered accountant or the cost accountant, shall be determined and paid by the commissioner, and such determination shall be final. Subsection 6. Where the special audit conducted under the subsection 1 results in detention of the tax not paid or short paid or anomalously refunded or input tax rate wrongly availed or utilized, the proper officer may initiate action under the section 73 or the section 74. Inspection, search, seizure, and arrest. Section 67 to 72. Section 67. The powers of inspection, search, and seizure. Subsection 1. Where the proper officer, not below the rank of the Joint Commissioner, has reason to believe that a taxable person has suppressed any transaction relating to supply of goods or services or both, or the stock of the stock goods in the hand, or has claimed input tax rate in excess of his entitlement under this act, or induced in the contravention of any provisions of this act or the rules made thereunder to evade the tax under this act, or any person engaged in the business of transporting goods or an owner or operator of the warehouse or the godown or any other place in keeping goods which have escaped the payment of tax, or has kept his accounts or goods in such a manner as is likely to cause evasion of tax payable under this act, he may authorize in writing any other officer of the central tax to inspect any place of business of the taxable person or the person engaged in the business of transporting the goods, or the owner or the operator of the warehouse or the godown or any other place. Subsection 2. Where the proper officer, not below the rank of the Joint Commissioner, either present to the inspection carried out under subsection 1 or otherwise has a reason to believe that any goods liable to the confiscation or any document or books or things which in his opinion shall be useful for or relevant to any proceedings under this act are segregated in any place, he may authorize in writing any other officer of the central tax to search and seize, or may himself search and seize such goods, documents, or books or things, provided that way it is not practicable to seize any such goods. The proper officer or any officer authorized by him may serve on the owner or the custodian of the goods and order that he shall not remove, part, or otherwise deal with the goods except with the previous permission of the such officer. Provided further that documents or the books or things so seized shall be retained by such officer only for so long as may be necessary for their examination and for any inquiry or proceedings under this Act. Subsection 3. The documents, books, or things referred to in the subsection 2 or any other documents, books, or things provided by the taxable person or any other person which have not been relied upon for issue of notice under this Act or the rules made thereunder shall be returned to such person within a period not exceeding 30 days of the issue of the said notice. Subsection 4. The officer authorized under the subsection 2 shall have the powers to seal or break open the doors of any premises or to break open any almirah, electronic device, box, in which any goods, accounts, registers, or documents of the person are suspected to be concealed, where the access to such premises, almirahs, electronic device, box, or recipitals is denied. Subsection 5. The person for whom the custody any documents are seized under the subsection 2 shall be entitled to make the copies thereof or take extract therefrom in the presence of the authorized person at such place and time as such officer may indicate in his this behalf, except ways making such copies or taking such extracts may, in the opinion of the proper officer, prejudicially affect the investigation. Subsection 6. The goods so seized under the subsection 2 shall be released on a provisional basis upon the execution of the bond and furnishing of the security in such manner and of such quantum respectively and may be prescribed or on the payment of applicable tax, interest, and penalty payable as the case may be. The subsection 7. Where any goods are seized under the subsection 2 and no notice in respect thereof is given within the 6 months of the seizure of the goods shall be returned to the person for whom the possession they were seized, provided that the person a period of 6 months may, on the sufficient cause being shown, be extended to the by the proper officer for the further period not exceeding 6 months. Subsection 8. The government may, having regard to the perishable or hazardous nature of any goods, depreciation in the value of the goods with the passage of time, constraint of storage space for the goods, or any other relevant consideration by notification specify the goods or class of goods which shall, as soon as may be after its seizure under the subsection to be disposed of by the proper officer in such manner as may be prescribed. Subsection 9. Where any goods, being the goods specified under subsection 8, have been seized by the proper officer or any officer authorized by him under the subsection 2, he shall prepare an inventory of such goods in such manner as may be prescribed. Subsection 10. The provisions of the Code of Criminal Procedures 1973 relating to such search and seizure shall, on so far as may be, apply to the search and seizure under this section, subject to the modifications and the subsection 5 of the section 165 of the said code, shall have the effect as if for the word magistrate wherever it occurs the word commissioner was substituted. The subsection level, where the proper officer has a reason to believe that any person has evaded or is attempting to evade the payment of tax, he may, for the reasons to be recorded in writing, seize the seize the seize the accounts, registers, or documents of the such person produced before him, and shall grant a receipt for the same, and shall retain the same for such long as may be necessary in connection with any proceedings under this Act or rules made thereunder for the prosecution. Subsection 12. The Commissioner or the officer authorized by him may cause purchase of any goods or services or both by any person authorized by him from the place business premises of any taxable person to check the issue of the tax invoice or issue of supply by such taxable person, and on receipt of the goods so purchased by such officer, such taxable person or any person in charge of the business premises shall refund the amount so paid towards the goods after cancelling any tax invoice or bill of supply issued earlier. Inspection of the goods in movement. Section 68. Subsection 1. The government may recognize the person in charge of conveyance causing any consignment of goods of value exceeding such amount as may be specified to, to carry with him such documents and such device as may be prescribed. Subsection 2. The details of documents required to be carried under subsection 1 shall be validated in such manner as may be prescribed. Subsection 3. Where any conveyance referred to in subsection 1 is intercepted by the proper officer at any place, he may require the person in charge of the said conveyance to produce the documents prescribed under the said subsection and device for the verification, and the said person shall be liable to produce the documents and device and also allow the inspection of the goods. Section 69. The powers to arrest. Subsection 1. Where the Commissioner has a reason to believe that a person has committed any offense specified in the class A or B or C or D or of the subsection 1 of the section 132, which is punishable under the class 1 or class 2 or of the subsection 1 or subsection 2 of the said section, he may by order authorize any officer of the central tax to arrest such person. Subsection 2. Where the where the person is arrested under the subsection 1 for an offense specified under subsection 5 of the section 132, the officer authorized to arrest the person shall inform such person of the grounds for arrest and produce him before a magistrate within 24 hours. Subsection 3. Subject to the provisions of the Code of Criminal Procedure 1973, where a person is arrested under subsection 1 for any offense specified under the subsection 4 of the section 132, he shall be admitted to bail or in default of a bail forwarded to the custody of the magistrate. In the case of non conjurable and bailable offense, the deputy commissioner or the assistant commissioner shall, for the reasons of releasing an arrested person on the bail or otherwise, have the same powers and be subject to the same provisions as an officer in charge of an of police station. Section 70. The powers to summons the person to give evidence and produce document. Subsection 1. The proper officer under this Act shall have the powers to summon any person whose attendance he considers necessary either to give evidence or to produce a documents or any other thing in any inquiry in the same manner as provided in the case of the civil code under the provisions of the Code of Civil Procedure 1908. Subsection 2. Every such inquiry referred to in the subsection 1 shall be deemed to be the judicial proceedings within the meaning of the Section 183 and the Section 228 of the Indian Penal Code. Section 71. Access to the business premises. Subsection 1. Any officer under this Act authorized by the proper officer not below the rank of Joint Commissioner shall have access to any place or business of the registered person to inspect books of accounts, documents, computer programs, computer software, whether installed in a computer or otherwise, and such other things as may require, and which shall be available to such place for the purpose of carrying out any audit, scrutiny, verification, and checks as may be necessary to safeguard the interest of the revenue. Subsection 2. Every person in charge of the place referred to in the subsection 1 shall, on the demand, make the payment available to the officer authorized under the subsection 1 or the audit party deputed by the proper officer or the joint commissioner or the cost accountant or the chartered accountant nominated under section 66 such records as prepared or maintained by the registered person and declared to the proper officer in such manner as may be prescribed. Trial balance or its equivalent, the statement of annual account, the financial accounts duly audited wherever required, the cost audit report, if any, under the section 148 of the Companies Act 2013, income tax audit report, if any, under the section 44AB of the Income Tax Act 1961, and any other relevant records for the scrutiny by the officer or the audit party or the chartered accountant or the cost accountant within a period not exceeding 15 days from the day when such period demand is made or such further period as may be allowed by the said officer or the audit party or the chartered accountant or the cost accountant. Section 72. The officers to assist the proper officer. Subsection 1. All the officers of the police, railways, customs, and other officers engaged in the collection of land revenue, including the village officers, officers of state tax, and the officers of the union territory tax, shall assist the proper officer in implementation of this act. Subsection 2. The government may by notification empowers and require any other class of officers to assist the proper officers in the implementation of this act when called upon to do so by the commissioner. Thank you very much for today. We shall catch up tomorrow.